Good afternoon, everyone. I welcome you all to the webinar of ICSR IIP on the topic Anatomy of IBC Cases. The entire webinar is divided into two sessions of 1.5 hours each. So the first session will be taken by Mr. Ankit Goel, and he'll be discussing following three Supreme Court cases: Orator Marketing Private Limited versus Samtex Designs Private Limited, Civil Appeal number 2231 of 2021, order dated 26 July 2021. Second one is Lalit Kumar Jain versus Union of India and another's transferred case, civil appeal number 245/2020 and other writ petitions, order dated 21 May 2021. And the third one is India Resurgence ARC Private Limited versus Amit Metallics Limited and others, civil appeal number 1700 of 2021, order dated 13th May 2021. So in case you have any questions, please post the same in the chat box, and I'll be taking all the questions at the end of the session. And I'll briefly provide you the introduction of Mr. Ankit Goel. Mr. Ankit Goel, his qualification is BCom Honors LLB FCA Registered Valuer, Insolvency Professional, etc. He's a founder partner of AAA Valuation Professionals LLP and AAA Insolvency Professionals LLP. He's a managing partner in AAAG and Company LLP Chartered Accountants and director in AAA Capital Services Limited. Mr. Ankit Goel is a regular speaker for insolvency valuation and forensic audit subjects at various forums. So you may now start the session.
Thank you so much. Thank you. And good afternoon to all the fellow professionals who have joined me. And many of you are very, very experienced and much more experienced than me. So rather than having maybe a Q&A session at the end, let's keep this as a very, very interactive discussion on the case laws that we'll be talking about. And it will be my pleasure to understand from all of you if there are any related case laws to the case laws that we are discussing that would need discussion and that would need deliberation to make this discussion more productive for everyone. So I'll share my screen and let's take up the first case first and then take it forward from there. Just give me a second. So so the first one is Lalit Kumar Jain versus Union of India. This is a 2021 judgment, May 2021. And I'll just reconfigure my screen so that I can see everything. So basically, in the batch of matters before the Honorable Supreme Court, there was this MCA's notification dated 15/11/2019, which concerned the validity of IBC and the application to adjudicating authority for insolvency resolution process. And it brought into force these sections. It talked about how the section 2, when you talk about the last part, that is part E, was brought into force. And this was, of course, the first stepping stone. Unfortunately, today again, there is a validity or there is a process which is pending in the Supreme Court of India for adjudication, which is preventing all personal guarantee applications to proceed forward. And this one is based on two issues. One issue is with respect to the issue with equity. Can you differentiate individual guarantors or personal guarantors who have given guarantees to corporate debtors from other individuals? See, these other individuals can be personal guarantors to an individual, a proprietorship concern, personal guarantors to a partnership concern, personal guarantors to maybe an individual loan. So these are all different guarantees. Then, of course, there are other individuals where the debt is not because of a personal guarantee. So those people are still not, the creditors are still not eligible to take them into insolvency, but these personal guarantors can be taken to insolvency by a creditor on default because of the new process. So this is the process, or this is the question that is still pending with the Supreme Court for hearing, and we are seeing different processes or different practices being followed by different NCLTs across India. And some NCLTs are allowing the individual bankruptcy to start, others are not allowing the individual insolvencies to start, and others are not allowing individual insolvency to start in the first stage itself, where the application itself is not admitted. Other courts are admitting the application, but then they are not moving beyond the stage where the report is filed under Section 99. The interesting part about the law is that the law is structured in such a manner that the moratorium for the individual starts from the date of filing. So this is again being used now against any SARFAESI action or prospective SARFAESI action by many personal guarantors, that they go and they file an application or keep an application ready for their own personal insolvency and think that the day the bank will initiate SARFAESI action, we will file our application before NCLT or DRT, NCLT before NCLT, and get a stay on the and get a moratorium on the all proceedings, including the SARFAESI proceedings. So let's move forward and understand the facts of this case. So the petitioners in this case had furnished personal guarantees to banks and financial institutions, which led to release of advances to various companies, which the petitioners were associated with as directors, promoters, or in some instances as chairman or managing directors. So when this notification came into being, the basically individuals could have been the institution of insolvency process against individuals was started. And after publication of the notification, many petitioners were served with demand notices proposing to initiate insolvency proceedings under the code. These demand notices were based on various counts, including that recovery proceedings were initiated after invocation of guarantees. This led to initiation of insolvency resolution process under Part 3 of the code against some of the petitioners. So the issues at hand in this judgment, which this judgment dealt with, was first whether on approval of resolution plan, the liability of the personal guarantors to the corporate debtor gets extinguished as the liability is coextensive. Whether the impugned notification was constitutionally valid, whether there was exercise of any excessive delegation by the executive, whether the impugned notification takes away the protection of the personal guarantor afforded by law under the contract of guarantee, and then there was reference to the Contract Act. What were the observations that the court made? The observations were that the sanction of resolution plan and finality imparted to it by Section 31 does not per se operate as a discharge of guarantor's liability. Then the resolution plan, which states that the claim of the guarantor on account of subrogation shall be extinguished, cannot be applied to the guarantees furnished by erstwhile directors of the corporate debtor, and they quoted COCSR versus Satish Kumar Gupta in this case. Then an involuntary act of principal debtor leading to loss of security would not absolve a guarantor of its liability. Then they quoted Maharashtra State Electricity Board, Bombay versus official liquidator. So any scenario where anyone can share that there is a possibility that the resolution plan also in a way indirectly deals or manages to deal with the discharge of the guarantor's liability or shift in the guarantor's liability. Anyone who can share any scenario where this shift actually happens? I think, and all of you can unmute yourself in case you want to. All right, no worries. So this happens normally in cases of assignment, and there are cases where the debt is not settled through payment or through payment of the creditors, but the debt is sometimes settled through an assignment mechanism, and that assignment is specifically selected where the non-assignment of the debt will lead to a large tax liability for the corporate debtor. So that is one process. Assignment is one way where the liability actually shifts to the the resolution applicant or the person assigned by the resolution applicant. So the observations, and it was held finally that approval of resolution plan does not ipso facto discharge a personal guarantor of her or his liabilities under the contract of guarantee. As held by this court, the release or discharge of principal borrower from the debt owed by it to its creditor by an involuntary process, by operation of law or due to liquidation or insolvency proceeding, does not absolve the surety or guarantor of his or her liability which arises out of an independent contract. So in case the bank has taken, let's say, given a loan, let's say there is a security of 100 crores, the bank has given a loan of, let's say, 200 crores. 200 crores become 300 crores because of interest and other penalties. And the 300 crores is the liability due to the bank. And the 100 crore asset is sold, 100 crores is received by the bank. But what else does the bank still have? The bank can have other collateral securities which are in the name of, not in the name of the corporate debtor. It can still pursue those guarantees. The bank can again pursue the personal guarantees that are obtained. When the loan is disbursed, before all these guarantees were invoked and all this has come into action, the thought process was that the bank will not invoke the guarantee beyond the value of the loan in case the bank has already realized the value from the sale of the collateral security. But then that, of course, has been a myth. And many people have signed loan agreements thinking that, oh, the loan is 200 crores. The mortgaged or the mortgaged property is worth 100 crores. And the personal guarantee is also 100 crores. So in case the bank will not exercise, not get money from the collateral security, then it will come to the personal guarantors. But the fact is that the bank can come after the mortgage property as well as the personal guarantors. It has both the rights. So then analysis of the provision. So while arguments were made that section 1.3 of the IBC does not confer power to notify parts of provisions of the code or to limit its application, the impugned notification is ultra virus to the provisions of section 1.3 of the IBC. The Honorable Supreme Court, in light of various judgments, observed that since the said act of modification with enactment does not constitute an essential legislative function, the provisions would not be ultra-virus. This argument of the petitioners was also set aside. Then the Honorable Court was of the view that parliamentary intent of the notification was to treat personal guarantors differently from other categories of individuals. And prior to 2018 amendment, insolvency proceedings against the personal guarantors could only be initiated under the Presidency Towns Insolvency Act and Provincial Insolvency Act, and consequentially, the intimate connection between such individuals and corporate entities to whom they stood guarantee was getting affected when two separate processes were being carried on in different forums, leading to uncertain outcomes and putting personal guarantors in the shoes of separate species of individuals. So the least but not the least argument that was put before the court was that when a resolution plan is accepted, the liability of the guarantor whose liability is coexistence with the corporate debtor also gets discharged. So again, they said that the notification by applying the code to personal guarantors deprives the guarantor of their valuable rights under sections 128, 133 of the or 144 of the Indian Contract Act. So the Honorable Court held that the approval of the resolution plan does under section 31 of the IBC does not ipso facto discharge a personal guarantor of her or his liability under the contract of guarantee, as the language of section 31 makes it clear that approved plan is binding on the guarantor in order to approve or in order to avoid any attempt to escape liability under the provisions of Contract Act. So by instrumentality of this judgment, the Honorable Court agreed that time and again on involuntary act of the principal debtor has led to loss of security, and the same would not absolve a guarantor of its liability. The release or discharge of a principal borrower from the debt owed by it to its creditor, or by involuntary process, by operation of law, or due to liquidation or insolvency proceeding, would not absolve the surety guarantor of his guarantee. So they said that it's an independent contract. There is no escaping the liability for the guarantor, and this argument is not acceptable, that because the primary liability of the company has been in a way settled by a resolution plan, the process is not available for, or the ancillary process for the guarantors is not available. Any questions, any queries, any further discussion before we proceed to the next case law from anyone? Any discussion that you feel is required on the personal guarantors insolvency subject? Difficulties or experiences that somebody will like to share with others? Anu, I hope everyone can unmute themselves, right? Or is there have you limited that as an administrator?
Yes, everybody can unmute
Yeah,
themselves.
I just wanted to check on that. So any comment, any suggestions are most welcome. If not, then we will proceed to the next case law.
So, Mr. Goel, just one point. It's exactly not a question.
Mhm.
But after this Lalit Kumar Jain, I mean, it's a very landmark case where this position is settled that this resolution plan would not bail out the personal guarantor. Has there been any other this kind of case has come up after this, or it is now understood by everyone that personal guarantors per se cannot be cannot extinguish their liability even if the resolution plan has taken care of the CIRP.
So the idea is not that, so if the resolution plan takes care of the complete liability of the creditors, then they have no option but to come to the personal guarantors. They're only coming after the personal guarantors for the remaining amount, sir. So this needs to be clear that the resolution plan will give some value to the creditors. They will come to the personal guarantors only for the remaining value. So the hierarchy is very clear. That the bank is having what? The bank has given a primary loan to the CD against the assets of the CD, let's say. So the primary security would be the maybe assets of the CD. Then there might be additional security in the form of collateral security, which is held in the name of certain individuals or other companies and so on, or other guarantors. Then there can be a third layer. The third layer can be personal guarantors or corporate guarantors. So the bank will normally choose to go through this hierarchy. Some banks are choosing to go all in with attacking at every level to allow or not to allow any person or any of these parties who have given some kind of with whom the bank has any action that they can take, a right to take an action or right to sue. So the banks are then pursuing everything all at once as well.
Understood. Thank you.
But then with respect to personal guarantors, because of the other case which is pending with the Supreme Court of India, the personal guarantors are right now enjoying the free moratorium, which is coming to them at the expense of the creditors.
And this has been pending for how long? This case to be settled by Supreme Court?
If I'm not wrong, about 6 months,
6
and
months.
maybe longer. I don't have the information on the date, but yes, we are seeing that many other people are then attaching themselves to the same case. So first they passed a stay for about 30 applicants, 30 petitioners, then it was extended to another 17 or so. So this is how it is being extended, and the same case will decide the fate for all the guarantors. The argument there is that till the Section 99 report is filed, or rather the first hearing that is done on a creditor's petition in the court for initiation of insolvency against the individual, there is no process for giving an opportunity of being heard to the individual. So there the banks are now, what they're doing is that to differentiate from that idea, they are now serving a notice for initiation of individual insolvency to the individual guarantors before they file the application in the NCLT. So when that application is filed, or rather than that document is available, then the courts might see that case differently and allow the process to be the whole process to be proceeded with.
Okay. Thanks. Thank you very much.
Any other comment, query? All right, let's move forward then. So this is the next one is India Resurgence ARC Private Limited versus Amit Metallics Limited. This is again a May 2021 judgment. The facts here are that the appellant was a secured financial creditor of VSP Udyog Private Limited, corporate debtor. Then resolution plan was submitted by the resolution applicant, Amit Metallics Limited, and was considered for voting. The resolution plan of Amit Metallics got approved with 93% voting share of financial creditors. The appellant expressed reservations on the share being proposed, particularly with reference to the value of security interest held by it, and chose to remain a dissenting financial creditor. Now, the issue here was whether the considerations regarding feasibility and viability of the resolution plan, distribution proposed with reference to the order of priority among creditors as per statutory distribution mechanism, including priority and value of security interest of secured creditors, are matters which fall within the exclusive domain of the Committee of Creditors for consideration. So, with NCLAT proceedings, NCLT expressed its complete satisfaction after examining the salient features and financial proposals of a resolution plan approved by COC. Consequently, the resolution plan was approved by its order dated 2010-2020. Agreed by the order of Honorable NCLT, the appellant India Resurgence ARC Private Limited filed an appeal before Honorable NCLAT. The appellant contended that the resolution plan failed the test of being feasible and viable, as its security interest was not taken into consideration at the time of preparation of the resolution plan by the resolution applicant. The Honorable NCLAT rejected the contention of the appellant and upheld the decision of Honorable NCLT. So, agreed by the order of the Honorable NCLT, the appellant India Resurgence ARC Private Limited filed an appeal before Honorable NCLAT. The appellant contended that the resolution plan failed the test of being feasible and viable, as the security interest was not taken into consideration. The Honorable NCLAT rejected the contention of the appellant and upheld the decision of Honorable NCLT. The Honorable NCLAT observed that Section 34 of the IBC provides that COC may approve a resolution plan by vote which shall not be less than 66% of the voting share of financial creditors. On a plain reading of the provision, it is clear that the considerations regarding feasibility and viability of the resolution plan, distribution proposed with reference to the priority among creditors as per statutory waterfall distribution mechanism, including value of security interest of secured creditors, are matters which fall within the exclusive domain of COC. The tribunal could not interfere with the commercial wisdom of the COC. Observations of the COC were that as regards the proceeds of the consideration and approval of the resolution plan, it is now beyond a shadow of doubt the matter is essentially that of commercial wisdom of COC. The scope of judicial review remains limited to the four corners of Section 32 of the Code for the adjudicating authority, and Section 32 read with Section 61(3) of the appellate authority, quoting J.P. Kensington and K. Sasidhar. Financial proposal in the resolution plan forms the core of business decision of Committee of Creditors. Once it is found that all the mandatory requirements have been duly complied with and taken care of, the process of judicial review cannot be stretched to carry out quantitative analysis to a particular creditor or any stakeholder who may carry his own dissatisfaction. According to the code, the amendment in no way makes it binding for the COC to take into account the priority of secured interest and the value of security unless creditors belonging to same class are treated inequitably. So, therefore, no claim by the appellant can be put forth in the terms of amended Section 32B to assert that it should be given precedence due to the value of its security interest. Thus, what amount is to be paid to different classes of subclass of creditors in accordance with provisions of code and the related regulations is essentially the commercial wisdom of the Committee of Creditors, and a dissenting secured creditor like the appellant cannot suggest a higher amount to be paid to it with reference to the value of security interest. So this judgment is something which, of course, is talking about the distribution and the waterfall mechanism under Section 53. So time and again, NCLAT has taken a stand that the security interest need not be seen when the distribution is done to financial creditors. Now, this is a very difficult problem. Now, today, in case there are two financial creditors, one financial creditor has taken a decision to be 100% secured, and he keeps a good margin, and he lends based on the idea that, okay, the security interest should be good for me to recover my amount from the company. And there's this other financial creditor who is an unsecured financial creditor. He has then given maybe a loan of much more money without adequate security. So how many of us here in this forum think that it is okay to say that both of them should get money through the waterfall mechanism for the resolution plan value or the liquidation value based on their voting share in the COC, and irrespective of what security interest they hold with them? Because in case you create a scenario where you say that every financial creditor is equal, then it will be a big problem for secured lending in India. Then many people who are lending on the basis of security will feel that their business model of lending with security or with complete security is going to fail in case IBC comes into effect with respect to that particular CD. So this case is also pending. There is another case which is pending in the Supreme Court of India, which is technology development, Kotak Mahindra Bank versus Technology Development Board of India. Now, this case was here the NCLT Ahmedabad in the matter of Gujarat Oleo Limited, which is a matter where Mr. Ankit Goel was the RP, had NCLT had held that the distribution based on giving due effect of the security interest is fine. NCLAT had reversed that judgment, and Supreme Court had stayed the judgment of NCLAT, effectively making the NCLT judgment applicable in that particular case. Here, when a minority creditor has gone to Supreme Court saying that we should have got more money because of our higher security interest, the discussion has not happened on the requirements of a resolution plan. Requirements of a resolution plan clearly state that the value which falls to a dissenting financial creditor should at least be that value that is available to him in case of liquidation and in case of distribution under Section 53, under the waterfall mechanism. So the question now is that in the waterfall mechanism itself, do you say that you forget all the charges, first charge, second charge, security value, when you are allocating value to the secured creditors under that provision? Or you take into account those security interests? So that's a question that is, I believe, answered here, that irrespective of the security interest, you would not get a higher value. But we don't see the argument in this case law on the fact that the resolution plan is non-compliant, because what they said is that they debated based on the idea that the debate happened based on the idea that the resolution plan is not meeting the criteria of feasible and viable. But there is another provision in the requirements of resolution plan that it should be based on the distribution to the amount allocable to a creditor should be at least the amount that is available to him in the liquidation process. So the other question that under Section 53, whether in case of liquidation or whether in case of CIRP process, how will Section 53 be interpreted? In that process, will this, when we talk about payment to secured creditors, will we make everyone equal irrespective of the security interest or not? So that question is again here. There's another case of SIDBI, which I think was decided by, if I'm not wrong, NCLAT. Again, where the similar situation happened, that SIDBI was fully secured through its security interest, and SIDBI filed an appeal saying that we have not got the distribution based on our security interest. But I don't think that matter is pending with the apex court. So this is the matter at hand. This is the confusion at hand. So any comments, any additions, any other experiences that somebody would like to share here?
Ankit, this Abhijit Jain here. Just just carry what just you have said with regard to the priority, whether its charge holder gets first charge or second charge. When it comes to section 53, it talks about secured creditors only. It doesn't differentiate between the first charge holder or the second charge holder. So I think that should be considered on a parity.
So that means that will then have a ripple effect, and that will put an end to secured funding in India, because many people are funding only based on the idea that they have adequate security against the loan. So and those who will be funding or lending without any security will get an advantage in IBC. So then the question is that is that the intention that everyone comes on the same page? And also it will start a process which will also be difficult, because we've seen in a few cases of ours where a bank having 100 crore exposure, having no security, goes to the CD just before the insolvency is about to start and says that please just I will give you what you want, but you please give me that security over that vehicle that the company owns, which is worth 2 lakh rupees, so that I get the status of a secured financial creditor. So 100 crore rupee loan, 100 crore rupee financial creditor becomes a secured financial creditor and gets a far higher right in the entire company because of a 2 lakh rupees security. Is that okay?
That is not correct, but that is what I said. There is any any judgment in this regard.
This
it
is
talks
the
about
that's the judgment I was talking about, the NCLT judgment, which is Technology Development Board versus Ankit Goel. Then appeal was filed that appeal was filed by Technology Development Board of India. Then that is pending with the Supreme Court of India for decision. So let's see. And right now because the NCLAT appeal, order has been stayed, at least in that case, the stand taken by NCLT, which was to say that secured lenders are the security is important to be considered when liquidation proceeds are distributed. That remains the law based on that judgment.
Ankitji, actually, in this particular judgment, I think it is a very simplistic view which NCLT or NCLAT has taken on the issue, because it cannot be just left to the commercial wisdom. I think is being extended to what a level, because this is one area where as you rightly said, that the security is such an important topic, and secured lending, that is the backbone of infrastructure or any kind of funding for economic growth. So there has to be much more deliberation on the topic. Maybe some weighted kind of weightage has to be definitely given to the proportion of security interest one lender has and the other doesn't have. Yeah, it is not only the just categorized under secured creditor and then get a benefit out of it. I mean, that would be too much of a simplistic view, and that cannot be also left to the, I suppose, this is my personal view, to the COC's commercial wisdom, whatever level you take it.
Then that clause which talks about the dissenting creditor getting at least his value under the waterfall mechanism will become useless.
Sir,
that will also become a problem. Yes, sir.
Sir, I am Tapan Chakraborty here.
Yes, Tapan.
Actually, if you consider the earlier regime prior to IBC, in the company matters, the office of the official liquidator, while they were settling the issues, they were taking into consideration the security part of it only, and the charge holder, first charge holder, second charge holder, like that, and proportionately they are actually settling their dues. I think this IBC has also taken some of the cues from that particular Company Act, which was the earlier regime. And if that act is followed, the rationale lies that actually while the section 53 waterfall mechanism to be considered, the question of weightage of security has to be considered and accordingly to be settled. And that is the rationale of what I find from my side. And I think Supreme Court will be going to that side of it.
Yeah,
no,
so
absolutely.
Sorry to interrupt. No, till such time, since there is no clear-cut judgment yet. So while distribution, can we consider, or the way we are doing actually, like till such time we are considering all secured creditors in the same, it's at par with regard to, irrespective of their security, whether the first charge or the second charge.
So that will be that is something that will be perhaps that see, because the COC also sometimes looks at the insolvency professionals for guidance on what is the latest legal position. There, this conflict with respect to how this is required to be interpreted is there, and therefore bringing this to the attention of the COC, or rather those members who are affected by this decision, is important. In many COCs, the majority secured, the majority voting shareholder is also perhaps can be the majority security holder. But there can be cases where that is not the case. So there the litigation will happen, the entire settlement will get extended. We have seen how a dispute between the creditors on distribution proceedings in the case of Reliance has now been decided by the court, and it has been said that, okay, you put the money into the escrow account and you get the money when you resolve your dispute. But the resolution applicant should take the company and then convert and try and resolve the stress. So that will be there. Our understanding and our saying, of course, this case law is, of course, it's a very specific one which has come in after looking at the joint reading of this case as well as the judgment of NCLT in the other case where the appeal is pending with the Supreme Court of India. It becomes even more important for the court to decide on this. So let's see how this can be taken up. Our understanding is that our take, and I think most people would say that understanding or giving value to the security interest or giving weightage to the security interest is important in liquidation when you are following the waterfall mechanism. And therefore, it is also important to identify if any creditor is getting less than his security value in a resolution plan. So, okay, so I think let's take it forward. This is one. Then we have Orator. The third one is Orator Marketing Private Limited versus Samtex Designs Private Limited, in April 2021 judgment. The fact in this case was that Samir Sales Private Limited was the original lender in the present case. It advanced a term loan of 1.6 crores to MS Samtex Designs without any interest for a period of 2 years from the date of execution of the loan agreement entered between Samir Sales Private Limited and Samtex Designs Private Limited. The loan agreement was entered between the parties on 20th January 2018, and the loan was due and payable after 20th January 2021. So it was a 3-year agreement that they had, and the parties herein were sister concerns. Samtex Designs Private Limited had taken a loan of 14 crores from Tata Capital Financial Services Private Limited, and thus it mortgaged all the assets in favor of the institutional lender. However, this loan facility was not sufficient to meet the working capital requirement of the corporate debtor, and therefore Samtex Designs decided to avail an interest-free loan of 1.6 crores from its sister concern, which is the original lender. It is crucial to mention here that this loan disbursed by the original lender was later assigned by it to MS Orator Marketing Private Limited. So the issue was whether a person who gives a term loan to a corporate person free of interest on account of its working capital requirement as a financial creditor competent to file an application under Section 7 of the code. So before we look at the judgment, any idea or any suggestion on what should be the decision, or what is the decision, or what is your take on this issue? Anyone who feels that this should not be considered as a financial creditor? Maybe you can share your thoughts along with the reasons because of which you think so.
It appears so, Ankit ji, because this time value of money, assumes that there must be a time value. That means the interest component must be there in such kind of loan. So it appears that whether this entity can be really considered as this is a financial creditor as such, yeah, as per section 7.
Any other views? Anyone
Sir,
else was
I am
putting
an
this?
ex-banker, sir.
Yes, sir.
Ex-banker. So in my opinion, normally bankers will give interest-free loan. So
Bankers
simply
will
because
give.
of
Okay.
simply because of they are not charged, it is interest-free loan. The right of financial creditors should not be excluded. Sir. They are financial creditors. They are giving interest-free loan in the interest of the institution. They say further pumping in money, position will improve. It should not be go against the creditor.
Okay, all right. Okay, then let's take it forward. So, in NCLAT, the assignee Orator Marketing Private Limited filed a petition under Section 7 of the Code before NCLT, and Honorable NCLT rejected the application primarily on the ground that since the loan extended by the appellant was interest-free, it could not constitute financial debt as defined under Section 5(8) of the Code. So, as Kabir sir said, this is the same stand taken by NCLT. Honorable NCLT relied on its judgment in Dr. BVS Lakshmi versus Geometrics Laser Solutions Private Limited and the decision of the Honorable NCLAT in Shreyas Realtors Private Limited and Saroj Realtors and Developers Private Limited to reiterate the importance of time value of money in the classification of a debt as financial debt under the code. Agreed by the order of the Honorable NCLT, the appellant Orator Marketing filed an application before NCLAT. Honorable NCLAT dismissed the appeal and upheld the decision of NCLT as the loan extended by appellant did not entail interest. Honorable NCLAT perused the statutory definition of financial debt enumerated in the code and interpreted the same with respect to the relevant clauses in the loan agreement. NCLAT opinion that to classify a debt as financial in nature, it must entail repayment of interest on part of the borrowing. Observations of the SC, the Honorable Supreme Court disagreed with the view taken by the Honorable NCLT and NCLAT and allowed the appeal. The Honorable Court relied on the definition of financial debt as under Section 5(8)(f) of the Code to hold that even if no interest is payable upon the loan, the outstanding principal will qualify as financial debt. Section 5(8)(f) of the Code defines financial debt to mean a debt along with interest, if any, which is distributed against the consideration for time value of money. The court focused on the phrase if any to observe that the existence of obligation of interest repayment was not a condition precedent for classification of a debt as financial in nature. The definition of financial debt as enumerated under Section 5(8)(f) was inclusive and not exhaustive. Thus, the term financial debt cannot be interpreted in isolation without acknowledging the other relevant definitions which are claimed under Section 3(6), corporate debtor, creditor, debt default, financial creditor, and so on. Financial creditor can file an application if there is default and if there is any question with regard to the eligibility of the person filing Section 7 application, then it has to be interpreted in accordance with the terms used in the respective provisions. And holistic assessment of the definition given under Section 5(8) of the term financial debt means outstanding principal due in respect of a loan and would also include an interest thereon. If any interest were payable, if there is no interest payable on the loan, then only the outstanding will qualify as financial debt. So this is how the Supreme Court has interpreted this issue. They have said that interest or no interest, in case somebody has given debt, then so somebody has given a loan, then it will still be considered as a financial debt, and therefore a financial creditor will be the status given to that person. So what happens here is that, say, it seems here that in this case, the CD had first given a loan from its own sister entity, and this is a normal practice in our country that many times the bank says that, okay, we are giving you a 14 crore loan, where is your contribution in the purchase of assets or setting up this plant? And invariably for smaller entities, we see that this capital is brought in by the promoters through a loan. We also sometimes give this a name of quasi-equity. Quasi-equity, and even if the balance sheet is showing this as an unsecured loan, in the projections for bankers, we see that this is not an unsecured loan or this is not a liability, this is rather the promoter's capital. In certain sanction letters, it is also written that this loan will not be taken back by the credit by the lenders or by the promoters. So that's also there. But through this case law now, it seems that these friendly loans, there was a limitation in these loans when the New Companies Act came in, because the New Companies Act, in a way, limited the possibility of granting new loans. However, this agreement was still, this agreement happened under the new company law itself. So how was Section 183 taken care of by the lending company is a different issue here. But then the lending company now has to charge at least the bank interest rate or the SPI rate, the base rate, sorry, SPI base rate for the loans rendered by it. But here even that was not charged. But still, the company that lent the money assigned it to another company, and that company, that new company to which this was assigned, having no related party concern or no related party association with the CD, would also be entitled to vote in the COC. So this then opens a lot of doors for this kind of agreement. Now, in many places, we as RPs find out that the money has come in from somebody, but the nature of that money coming in is maybe the balance sheets are not even filed, so we are not able to understand the nature of that money coming in. So if there is no interest required to be charged, how do you protect the problems with respect to backdating of the agreements, loan agreements, and then somebody saying that, oh, I'm a financial creditor, and then somebody assigning that debt to somebody. So these problems will come up, and especially where related party financial loans or non-interest bearing loans are there. In some cases, these are also entries as we speak, where these are not real liabilities, but these are just liabilities which have been created because of some conversion transaction. So all these nitty-gritties will come out of the Pandora's box due to this judgment.
Yeah.
Any other feedback, suggestion that anyone has on this judgment? Any view, any other thought from anyone here?
Actually, it's surprising that this kind of a judgment has come from the Apex Court, when Apex Court itself had many cases, took a very stringent view of this time value of money. May not be interest, but time value of money, presumes that there will be a cost attached to it, and it must be visible. Otherwise, you can't draw a line, Ankitji. Yeah, you have to draw a line somewhere. And you open a floodgate in the process. You open a floodgate finally.
Because of this judgment, that any amount that has come to the company and which is sitting in the liabilities can be claimed as a financial debt, because then somebody can always have a loan agreement or some kind of an agreement. These issues will come up. These are all effects, but then I think the idea is that so far the understanding was the opposite. This kind of changes that. Yes.
So, one thing I would like to point it out over here: if the related party have given loan and they have assigned the loan to the other party, which is not related, they again become a FC, financial creditors, in this case. So it means any related party transactions also can be related party can also take the case in NCLT, in FC, as a FC.
Yeah, so the related party can take the case against FC. There is no bar on that. I don't think there is any bar anywhere that a related party FC cannot take the company to insolvency. But then that is not the usual practice, because the court can always say that you're related, and therefore, why shouldn't you file a section 10 application, why are you coming this way?
Correct.
But then the other concern is that before the insolvency process initiates, the company can plan, and all the related party loans that a company has taken from its sister entities can be assigned to a non-related party.
And
it
then
can be
they will
anyone,
take-
and then they will be charged of, or they will be important part of the COC. Because earlier this approach was taken by promoters to be part of the affairs of the COC, because they were not shared, or all
Correct.
information was not shared with them. However, now that is settled, and the promoters are also allowed to be part of the COC meetings, and therefore they are not there for information, but then now they will be there for control, or rather a
Basically
say in the
control.
whole process. Yeah.
Yes. Yeah. Good, sir.
So that's this case. I think we have a lot of time, so we can discuss something else in case somebody has something on their mind, and we can discuss that. I can try and dig out any judgment online, or in case there is any other discussion required, we can dig out that. In case there are any other topic of discussion that anyone would like to suggest, we can have a discussion on that also. So the IPE framework is, of course, there now. It's live on IBBA website.
Which?
And the IPE is becoming IPs. That framework is live now. Other changes that have happened in the insolvency process, even, of course, all of those processes are also live now. We are, of course, reading about, I think yesterday or today, there was a news on some changes or regulations being brought in for real estate cases. So let's see what comes up there, and we will perhaps see some kind of a draft regulation maybe before it comes in, and then understand that what are the reliefs there, because there are a lot of real estate cases which are stuck in the insolvency process and not getting a resolution because of different issues.
Correct. Nowadays, sugar mills are also coming into a big number for insolvency. So again, in Maharashtra, there is some government talks is going on to how to help them. That is also one of the new things is coming up in Maharashtra.
So the government will subsidize the companies.
They are saying that the ARCs should take that loans from bank and do some restructuring and all the things. So that way they are planning. Now, for what they will do and how they will do is not clear right now. But
again, commercial wisdom of the banks will prevail.
Correct.
The value at which it will get transferred to an ARC is also important, or the value realization through the ARC is also important. And most of the sugar mills, sometimes there's a local problem in a particular state because of the price mechanisms that are there, or price controls that are enforced in a sugar industry. That might be the issue at hand. If there's a concentration of defaults in a particular state. So, but I'm not sure about that. I'm just commenting widely about it. I'm not sure if every sugar factory in Maharashtra is, or every, or more than the usual sugar factories are sick in Maharashtra. But I think sugar factories are having a problem across India, especially in those states where there is a very, very high price that they have to pay to the farmers. So that issue is a perpetual issue, and I think that has been going on for years and years today, because the sale price is not controlled, but the purchase price is controlled. So it's difficult for everyone.
Kabir, you want to say something?
No, I was only endorsing what Ankit ji has said about sugar. This is the purchase price is controlled, and where there lies the many issues as regards the viability of why so many sugar mills fall sick. Yeah, although sugar is such a common item and it has a huge demand, but why they can't be profitable? One of the reasons which Ankit ji just said. So I was just only endorsing that. Thank you.
If anybody has any questions relating to the 3 judgments explained by Ankit Goel, then you may please ask. Okay, so we can end this first session here. Thank you.
Yeah, I have one question.
Yes, sir. Yes, Gaganji.
Sir, slightly different from what we discussed, but in a company where operational creditors are to the tune of say 50 crores, and there is just one small car loan, say maybe with an outstanding of 5 lakhs or so. So would in that case also COC would consist only of one loan financial creditor and having a very meager outstanding?
There is a provision, right, where the any operational creditor who has a claim of more than 10% of the financial creditor claims is also required to be made part of the COC. I think in this example that you have stipulated, both the people will become a member in the COC because of that stipulation, or the OC will get the entitlement to participate in the COC. That would how this will act. So recently I got a interesting question that the financial creditor made a claim. The company was a company where perhaps there were no assets. So the financial creditor then wanted to withdraw his claim because otherwise he would have been liable to incur the costs associated with the CRP. So I also checked, but then I could not find any provision for the financial creditor to be able to withdraw his claim. And that's something that is also there, although that was not related to what you asked, but I just remembered that and thought I will share that as well. Any other views on Gagan sir's query from anyone?
Actually, the OCs, though they may be having more than 10% of the total claim, but they will not be the member of the COC. They can participate. That's all.
Participate. They will not have voting share.
Yeah, they will not.
Yeah, they won't get voting
They will.
rights.
There again, where the financial creditor takes a decision which is totally sidelining the operational creditor's interest. The operational creditor going to the court and saying that despite this kind of a difference in the values that were at stake, he has got nothing and nothing at all. He might get some relief, but again, there the recent judgments from the apex court is that operational creditors should get only their liquidation value. So in this case, as you said, that the entity which has that car loan will take the call on what resolution plan to approve. That is the law as on date. But then maybe participation of or rather consultation with the OC will lead to a successful resolution plan by avoiding any future litigation. That might be the practical approach here. Although the voting will still be with the FC. The NFC will be interested in a resolution plan which deals with his debt as well as the OC's debt, so that the resolution takes place rather than going into further dispute. So that's something that we do wherever OCs are larger or OCs are having a special interest, we normally try to convince FCs to take into account the interest of the OCs in the plan that they're passing to avoid litigation.
Okay, so are there any other questions? So on behalf of everybody, I'd like to thank Mr. Ankit Goel for taking up the session. I think 2 major takeaways that we have from your session is that the interest-free loans advanced to finance the business operations of a corporate body is also interpreted as a financial debt for the purpose of making applications for initiation of CIRP, and also that the amount to be paid to the creditors is essentially the commercial wisdom of the Committee of Creditors. Thank you so much, sir, for taking the session. And now we'll have a break for 10 minutes and then we can start another session.
Thank you, Ankit ji.
Thank you, Ji. Thank you everyone for participative session, and I would say good learning for me, and hopefully it was a great session for everyone and got a new perspective. So we say that our law is evolving, constantly evolving. So I think we understood a few more evolutions today. Thank you everyone.
Thank you, sir. Thank you.
Thank you, sir.
Good afternoon, everyone, once again. So the next session will be taken by Mr. Apoorv Sarvaria. He will be discussing two Supreme Court cases, Indus Biotech Private Limited versus Kotak India Venture Offshore Fund, earlier known as Kotak India Venture Limited and others. And the second one will be Lakshmi Pat Surana versus Union Bank of India and others. It was dated 26th March 2021. Let me briefly provide you the introduction of Mr. Apoorv Sarvaria. He is a practicing advocate, insolvency professional, arbitrator, and a former judge in Delhi district courts. He did his Master of Laws LLM from Indian Law Institute and LLB from University School of Law and Legal Studies from GGSIP University, Delhi. He is presently a partner at VGC Law Firm, heading over the liquidation and disputes resolution practice in the firm and also taking up the matters as interim resolution professional and resolution professional in different CIRP assignments. He has handled large debt recovery and infrastructure related matters. He has represented lenders and PSUs before Supreme Court of India, High Courts and other fora, including NCLAT, NCLTs, DRAT, NCDRCs, etc. He has advised many resolution professionals and CIRP assignments. Mr. Apoorv Sarvaria regularly publishes articles and write-ups on insolvency and bankruptcy laws and other commercial laws. Recently, he has co-authored a commentary on insolvency and bankruptcy code 2016 published by Taxman. He has also taught IBC to law students at Xavier Law School of Bhubaneswar, Odisha. Also, if you have any questions during the session, please post the same in the chat box. I'll be taking the session questions at the end of the session. And Mr. Apoorv Sarvaria, you may now start the session.
Thanks, Anu, and welcome everyone. I believe mine is the second part. So I think the initial part, when the people are very much fresh, has been taken over by Ankit. So, but anyways, we'll start with the session. I'll start with the first judgment of Kotak, the Indus Biotech. I hope everyone can see the screen. So this Indus Biotech Private Limited versus Kotak India Venture. So next slide. So we'll just quickly run through the slides and then we can also discuss the points which were involved by the Supreme Court in both the cases. First were the brief facts in this judgment of Kotak. This Kotak India Venture, this offshore fund, and three other respondents, they had subscribed to optionally convertible redeemable preference shares issued by the CD Indus Biotech Private Limited. And they were in accordance with the share subscription agreement and the shareholders agreement. So these optionally convertible redeemable preference shares were issued. Now, Indus had proposed to make a qualified IPO, and Kotak and the other three respondents. When I say Kotak, it means four respondents. They had elected to convert its OCRPS into equity shares prior to the QIPO. Now, the parties negotiated regarding the conversion rate and had references leading to disputes. And the dispute was regarding to the calculation and conversion formula to be applied in converting the preference shares into equity shares. Now, next slide. Then what Kotak did, it invoked its right to seek redemption of OCRPS in accordance with the terms of the agreement. Indus, which is the CD, it failed to redeem the OCRPS. Kotak approached NCLT seeking initiation of CIRP under Section 7. So the main dispute was regarding the rate at which the OCRPS had to be redeemed and converted into equity shares. Correspondingly, Indus filed an IA under Section 8 of the Arbitration and Conciliation Act. Section 8 talks about filing an application before the judicial authority where the dispute between the parties are pending to refer the matter to arbitration. Now, this was filed before NCLT, surprisingly, but it was done. And then the request was made by the CD, the corporate debtor, to refer the dispute to arbitration in accordance with the dispute resolution mechanism as agreed in the agreements. And what was the dispute resolution mechanism? Clause 20.4 of the agreements provided for an arbitration clause. Even the supplemental agreements to the share subscription agreement and the shareholders agreement provided and referred to the same clause 20.4, providing an arbitration clause. Next slide. Then the NCLT allowed the application filed under the Arbitration Act. and the petition filed by Kotak and other respondents under Section 7 IBC was dismissed. So there was a finding that there was no default. Then Kotak thus appealed before the Supreme Court. And now here's a very peculiar circumstance. Kotak and other respondents did not approach NCLAT. They directly went to the Supreme Court and against the order passed by the NCLT. The Supreme Court proceeded to entertain the SLP, special leave petition, as a special circumstance, as Indus Biotech had sought resolution of dispute through arbitration, as arbitration petition to that effect was already pending before the Supreme Court. So there were arbitration petitions which are pending, and this also covering a case of an international commercial arbitration. So in such cases, Section 11, Clause 6 of Arbitration and Conciliation Act applies, and the parties have to approach directly to the Supreme Court in such cases. So that's why, since the dispute was pending before the Supreme Court, as far as reference to arbitration was concerned, the Supreme Court also, in exceptional circumstances, without the appellant approaching the NCLAT and then coming to Supreme Court, directly took up the matter. Next slide. Now, what were the issues for determination? First is about how to determine the default, whether there was a default or not. Second, the arbitration, the duty of adjudicating authority, we would say, that whether the adjudicating authority can refer the disputes to arbitration, especially when the domain is of an adjudicating authority is only to decide whether a default is committed or not, and the proceedings need to be referred to CIRP. Yes, next. Now, what were the findings of the court? The Supreme Court, it upheld the decision of the NCLT and held that an application for initiation of CIRP under IBC is inadmissible until the parties attain a resolution through the arbitration process as provided in the agreements. So straight away, Supreme Court went ahead and said, look, we cannot see whether default is committed or not, because there is a dispute in terms of application of a particular formula, whether those preference shares need to be redeemed and converted into equity shares through a X formula or Y formula was in dispute. So in such scenario, they said the default, it is not conclusive whether a default is committed or not. And this was also given the circumstance, the company corporate debtor otherwise was a going concern, was running nicely. There were no other such defaults. Especially only the background was that this kind of dispute occurred when the QIPO was being initiated. The preference shareholders wanted to convert their shareholding into equity. So placing reliance on the decision in Innoventive, this is the landmark case, everybody must be aware already, Innoventive Industries versus ICICI Bank. It first observed the four factors which should exist while allowing an application under Section 7. First, there should be a debt. Second, there should be a default which could have occurred. Third, debt should be due to FC, and such default which has occurred should be committed by a CD. Then the Supreme Court also emphasized that a mere existence of a debt is not a determining factor for the establishment of a default. So the Supreme Court made a distinction that, look, there is a debt, that's fine, but whether a default is committed or not will depend not just because there is an existence of a debt. There has to be something else. There has to be a non-payment of ascertainable definite dues. So Supreme Court elaborated on how a duty is cast on the adjudicating authority to ascertain the existence of a default on a case-to-case basis and by relying on evidentiary records. And the SC adjudged that NCLT, the adjudicating authority, has the right to determine the occurrence or non-occurrence of a default. So when the adjudicating authority proceeds to admit the application, noting the occurrence of default, CIRP commences. And in such event, it becomes a proceeding in rem. This is important. This is the crux, main observation part of Supreme Court, where it said it becomes a proceeding in rem upon the admission of Section 7 petition. The proceedings become in rem as on the date of admission. And from that point onwards, the matter would not be arbitrable. So Supreme Court specifies, makes a stand. What happens, Dr. Singhvi, Abhishek Manu Singhvi, he appeared for Kotak and others. He made a submission that the moment a Section 7 petition is filed, the reference to arbitration should be taken from that point of time. So Supreme Court negated that and said, first, let the NCLT or the adjudicating authority give a finding whether default has occurred or not. Now the trigger point is date of admission, not the date of initiation of application. So from the date of admission, moratorium starts. And then since the moratorium will be applicable, in such cases, arbitration will, if at all, if they have commenced, then they will be stayed. Or if the reference to arbitration will be stayed because of the applicability of moratorium. However, first there has to be a finding of default. There has to be an admission order. Merely because an applicant has filed a Section 7 application does not mean that the matter automatically should go to arbitration or not go to arbitration, both ways. So the Supreme Court, no, last slide. The Supreme Court adjudged that the AA has the right to determine the occurrence or non-occurrence of a default. When the AA proceeds to admit the application, noting the occurrence of default, CIRP commences, and in such event, it becomes a proceeding in rem as on the date of admission, and from that point onwards, the matter would not be arbitrable. Therefore, the trigger point is not the filing of application under Section 7, but admission of same on determining default. Next slide. And the Supreme Court held that a mere claim cannot be ground for establishment of default. So just because you have a claim, that doesn't mean that the default is established. Whether that claim is admissible, whether there is a default which is being committed. So it's as good as saying X company owes liability to Y, but Y never demanded such claim. Why there was never a default. Merely because there is a claim subsisting doesn't mean that a default is committed. There has to be a notice of demand. So something on that ground, it said that merely because a claim exists doesn't mean that a default has been committed. If that were to become the norm, the companies which are running its administration effectively would become prey to the corporate insolvency resolution process. SC held that in the process of consideration to be made by the adjudicating authority, the facts in the particular case are to be taken into consideration. So facts will have to be determined on each and every circumstances. Even if there is that in strict sense of the term, it has to be ascertained whether a default has occurred or not. This is in para 20 of SCC. The Supreme Court also conclusively held that in situations where petitions under IBC are yet to be admitted, and in such proceedings, if an application is made under Section 8 of the Act, of the Arbitration Act, the adjudicating authority is duty bound to first decide to its satisfaction whether default has occurred or not, even if the Section 8 application is kept along for consideration. So Supreme Court says initial duty of NCLT or the adjudicating authority is to first determine whether default is committed or not, and then give a finding on admission of the application. Next. And now there are some observations of the Supreme Court that we've just copied and pasted here now. Initially were the bullets paraphrased. So underlying principle, first is para 26 of the Supreme Court judgment. It says the underlying principle from all the above noted decisions that relied on certain case laws, innovative and others, is that the reference to triggering of a petition under Section 7 of the Code to consider the same as proceedings in rem, it is necessary that the NCLT ought to have applied its mind, recorded in a finding of default, and admitted the petition. So the proceedings become in rem only after application of mind by NCLT, whether Section 17 has been admitted or not. On admission, third-party right is created in all the creditors of the CDs and will have erga omnes effect. The mere filing of the petition and its pendency before admission, therefore, cannot be construed as the triggering of a proceeding in rem. Hence, the admission of petition for consideration of the CIRP is the relevant stage, which would decide the status and the nature of pendency of proceedings. Mere filing of petition cannot be taken as triggering of insolvency process. So this is quite simple, just that Supreme Court declares or is reiterating a settled position That mere filing a Section 7 petition does not mean that the moratorium or the reference to admission will go back to that date of filing of Section 7. It has to be from the date of the admission order. Next slide. And further observations, in such application, the course to be adopted by the NCLT if an application under Section 8 of the Arbitration Act is filed, seeking reference to arbitration is what requires consideration. In that view, notwithstanding the fact that the alleged corporate of the Act, the independent consideration of the same dehors the application filed under Section 7 of IBC, and materials produced therewith will not arise. So independent consideration of same dehors the application filed under Section 7 will not arise. The NCLT is duty bound to advert to the material available before him as made available along with application under Section 7 of the code to indicate default along with version of CD. So just because there is a Section 8 petition pending does not mean that Section 7 will not be decided. So arbitration petition being pending does not mean NCLT will defer the matter or refer to arbitration. First, it has to give a finding on default because that is its main job. And okay, so NCLT is duty bound to advert to the material available before him as made available along with the application under Section 7 of the code to indicate default along with the version of corporate data. This is for the reason that, they give, reason that keeping in perspective the scope of proceedings under the IBC and there being a timeline for consideration to be made by the adjudicating authority, the process cannot be defeated via CD by raising moonshine defense only to delay the process. So what if it happens? Section 7, a petition is filed by a financial creditor, and then CD files an application. Look, there is an arbitration clause. Please refer us to arbitration. So in that event, any agreement where there is an arbitral clause will never go to CIRP. The financial creditor will never be able to trigger insolvency proceedings. The disputes have to be referred to arbitration, especially in cases where there is a definite default. So then Section 7 will never be able to trigger. But that is not the intention. So first, NCLT has to give a finding whether default is committed or not. Then look upon other things. So in that view, even if an application under Section 8 of the Arbitration Act is filed, the NCLT has a duty to advert to contentions put forth on the application filed under Section 7 of the IBC, examine the material placed before it by the FC, and record a satisfaction as to whether there is default or not. While doing so, the contention put forth by the CD shall also be noted to determine as to whether there is substance in the defense and to arrive at the conclusion whether there is default. So Supreme Court is not saying that you directly admit the application. Of course, CD has its own defense. Reply will be considered. Whether default is committed or not will be considered. And the defense will be considered. But don't refer the matter to arbitration without arriving at such a finding whether default is committed or not. So that is the main duty of NCLT. If the irresistible conclusion by NCLT is that there is default and the debt is payable, the bogey of arbitration to delay the process would not arise despite the position that the agreement between the parties indisputably contains an arbitration clause. So what does this mean? First is, we all know that Section 7 or triggering of insolvency proceedings is not a recovery process. It's not mere recovery process. It's for resolution. So it's for resolution for a company entering into a situation of insolvency, it needs to be resolved. So first, of course, primarily every creditor is applying Section 7 merely because everybody wants to recover the money. But as we know, the idea behind the code is to resolve a particular situation of a company or any individual who is undergoing an insolvency situation, so that we resolve for the better economy, of the country, so that we are able to assist that corporate debtor in arriving at a situation, in attaining a situation where it can revive its own businesses. So that is the main reason. But having said that, a CD cannot file an application under Section 8 and delay the adjudication of Section 7 application. Next. Further observation, if the conclusion is that there is default and the debt is payable, due to which the NCLT proceeds to pass the order as contemplated under Section 7(5)(a) to admit the application, the proceedings would then get itself transformed into a proceeding in rem. So, an admission order is passed, the proceeding in itself would get transformed to be a proceeding in rem, and it will have an erga omnes effect, due to which the question of arbitrability of the so-called interstate dispute sought to be put forth would not arise. What does that mean? Section 7 gets admitted, moratorium starts. So there is no point of having arbitration. It can't be, because arbitration means claims filed against CD, they cannot be proceeded upon once moratorium is triggered. So Supreme Court clarifies, NCLT has to give a finding whether Section 7 is admissible or not. If Section 7 NCLT says is admissible, admission starts, so there is no question of arbitration. In case, and then later we'll see, on the other hand, on such consideration made by the NCLT, if the satisfaction recorded is that there is no default committed by the company, the petition would stand rejected as provided under subsection 5B of Section 7 of the Code, which would leave the field open for the parties to secure appointment of arbitral tribunal in an appropriate proceedings as contemplated in law, and the need for NCLT to pass any orders on such application under Section 8 would not arise. So even otherwise, if the NCLT says there is no default and the Section 7 petition goes, it is dismissed, even then the need for giving or disposing of a Section 8 arbitration petition does not arise. That is what Supreme Court says. Next slide. So further observations, therefore, to sum up the procedure, it is clarified that in any proceeding which is pending before the NCLT or the adjudicating authority under Section 7 of the Code, if such petition is admitted upon the adjudicating authority regarding the satisfaction with regard to the default and the debt being due from the CD, any application under Section 8 of the Act, of the Arbitration Act, made thereafter will not be maintained. So Section 8 arbitral application under Arbitration Act will not be maintainable before the NCLT in a situation where the petition under Section 7 IBC is yet to be admitted, and in such proceedings, if an application under Section 8 of the Arbitration Act is filed, the adjudicating authority is duty bound to first decide the application under Section 7 of the Code by recording a satisfaction with regard to there being default or not, even if the application under Section 8 of the 96 Act is kept along for consideration. In such event, the natural consequence of the consideration made therein on Section 7 of IBC application would befall on the application under Section 8 of the Act. Next. Now, relying on the correspondences which were provided to it, the court adjudged that the moot point was and is the conversion of the OCRPS, the optionally convertible redeemable preference shares, and the allotment of equity shares against the OCRPS in view of the qualified IPO, which was still a matter of discussion between the parties. And hence, it was premature to determine if default had actually occurred at the given point of time. So here, the Supreme Court again comes back to the facts of the case. After pronouncing the law on how should NCLT approach where a Section 8 Arbitration Act application is filed, it goes back and says, look, there is no determination of default. It can't be determined since there is a question of application of what formula to be adopted while converting the OCRPS into equity shares. Supreme Court thus upheld the conclusion arrived by the NCLT, citing that default could not be established and hence deemed it necessary that the petition under IBC be dismissed and the petition under Arbitration Act is allowed. Now, here Supreme Court, in exercise of its inherent powers or an exceptional case, allows the Arbitration Act application by itself. But as regards qua NCLT, it gives the finding. NCLT cannot. It can keep that application pending till that Section 7 application can be disposed of, Section 7 IBC application. But it cannot itself refer the disputes to arbitration, be in cases of admission or in cases of rejection also. But here, in particular facts, since the matter was also pending before the Supreme Court in terms of international commercial arbitration being referred, the Supreme Court appointed arbitrators and allowed the arbitration application through its own jurisdictional powers under Section 11 of the Arbitration and Conciliation Act. This is the last slide. So this is the first case. We've completed that. Any doubts? Anu, if we are going to take doubts now or at the end of the second case?
We can take them now also.
We can take them now because we've just ended discussion on this case. So any doubts, any comments, any observations?
So if arbitration proceedings are pending, so CIRP cannot be initiated. That's the...
No, if arbitration proceedings are pending, Section 7 can definitely be filed. But the crux or the finding of Supreme Court here is duty of adjudicant authorities to first determine whether default is committed or not. It cannot by itself refer the matter to arbitration without disposing of the Section 7 petition, IBC petition.
So means you want to say that if default is there, then whether NCLT can accept the Section 7 application?
Yes, it will definitely. It has to. It has to. So merely because CD, now Section 8 Arbitration Act petition means there is an arbitration clause. And the CD says, since there is a dispute, please refer us to arbitration. Now that NCLT cannot do before disposing of the Section 7 petition. And in case Section 7 petition is allowed, then automatically moratorium comes in picture. If moratorium comes in picture, there is no question of arbitration.
Okay, got it.
So meaning thereby, if arbitration proceedings are pending before the court, so Supreme Court said that Section 7 can be kept down and the arbitration proceedings would prevail.
No.
If the arbitration proceedings are pending before any other authority except Supreme Court, then NCLT has to decide the Section 7 petition first.
No. Here also, Supreme Court first, it lays down the law. What is NCLT supposed to do in such a situation where a Section 7 petition is pending and a Section 8 arbitration reference to arbitration application is filed? So what should NCLT do? Thereafter, Supreme Court also first affirmed the finding of NCLT that yes, there is no default, because it is actually an issue which formula is to be adopted for conversion of OCRPS into equity shares. So the Supreme Court also first gives the finding that yes, there is no default. And then in exceptional circumstances where a Section 11 Arbitration Act petition was pending before Supreme Court. Now under Arbitration Act.
So that I am interrupting you. So that arbitration, whether those arbitration proceedings which were pending before the Supreme Court relates to the formula, what is to be decided on the formula?
Yeah. See, actually, before High Court or Supreme Court, when an arbitration proceeding in qua this is pending, it is not actually arbitration proceedings. These are for appointment of arbitrators.
Fine. Yes.
Right. So not that as if they are actually themselves going to decide this. So they refer the matter to arbitration because there is no default. Had they stated, Supreme Court stated that yes, there is a default, then I don't think so they would have referred the matter for arbitration because moratorium would have triggered. If moratorium gets triggered, then the claims will be admitted or not admitted or verified by the IRQ.
So in your opinion, what would be the picture in case the application for appointment of arbitrator is pending, suppose before the High Court?
Yes.
Right, and the same situation arises the other part in the NCLT. So what is to be decided first? So or in step 2 is whether, because the application for appointment of arbitrator was pending before the Supreme Court, so Supreme Court took their supremacy. Yes, because this is pending before the Supreme Court. So first it is to be decided.
No, so see, ultimately, these are all different. Now, ideally, when you see Section 11 pending before before High Court or Supreme Court, and then Section 7 is pending before NCLT.
Right.
So these are two independent proceedings. They can go on till both of them are pending together. Now, which one gets decided first? It really doesn't matter, because let's say High Court appoints an arbitrator before the disposal of Section 7 IBC petition. Let's take that scenario. So what does that mean? Arbitrator appointed, arbitration proceedings commence, statement of claim is filed, statement of defense is filed, whatever it is. In the meanwhile, Section 7 IBC petition are still pending, or let's say while filing statement of claim, or let's say the matter is in evidence, the arbitration proceedings go into evidence.
Right.
Now, at that stage, Section 7 IBC is allowed. What will happen if the claims are filed against the CD only? The moratorium will be applicable. Right. Now, second scenario, if Section 7 IBC petition is dismissed, then of course moratorium is not applicable. Proceedings will go on, arbitration proceeding will go on. So as such, I don't see any conflict anywhere. I hope, Vinayji, I'm able to clear your doubt.
Yes.
Yes.
Apoorv, this just one point. I think this SLP was NCLAT was bypassed here. Actually, they had gone directly to the Supreme Court.
Yes, NCLAT was bypassed, and here I have not really recorded these observations, but Supreme Court itself recognizes that this is a case where bypassing NCLAT, what happened? See, Section 7 IBC petition was dismissed by NCLT.
Yes.
Simultaneously, NCLT also allowed the Section 8 Arbitration Act application. Now, against the application which was allowed under Section 8, these Kotak is respondent. Sorry, I'm so sorry. The corporate debtor, I mean, he's not a corporate debtor because Section 7 was dismissed, but the alleged corporate debtor directly goes to Supreme Court saying, please interfere in the matter. NCLT should not have allowed Section 8.
Okay. But SLP is normally under normal circumstances, maybe the apex court would have rejected it. But because the arbitration is with apex court, they would have allowed such SLP.
Yeah, so that's why they clubbed all these matters. So if you see first slide, if you see the first slide, the petition numbers first name of the case. If you see, there was an arbitration petition, civil number 28 of 2019, and civil appeal number so and so. So there were two, and then two SLPs. So all these matters was clubbed and then together heard by Supreme Court, and then of course finding was given. So this arbitration petition between the same parties was pending. And was pending because it was an international commercial arbitration where the jurisdiction of the apex court lies.
Okay.
Any other doubts, comments, please? Any other observations?
You can continue, sir.
All right. Vinayji, I hope I cleared your doubt.
Yeah.
Right. Thanks. Okay, next case. Then you've done this one. Next is Lakshmi Surana. This is one of those cases that was decided in 2021 after the Bishal Jaiswal judgment. Yeah, so Lakshmi Surana, slideshow. Yeah. So facts of the case, first, so respondent number 1, which was the financial creditor that had provided credit facility to the principal borrower, which is Mahavir Construction, which is a proprietor. And there were two loan agreements of 2007 and 2008. Then corporate debtor, which is the corporate guarantor to a loan provided to a proprietorship firm. So Surana Metals Limited, of which the appellant is also director. So the appellant, Lakshmipad Surana, was the director of Surana Metals. So that Surana Metals Limited corporate debtor had offered guarantee to the two loan accounts of the principal borrower. The stated loan accounts were declared NPA in so-and-so year, and the FC issued a recall notice in February 2010 to the principal borrower, which is the proprietorship concern, as well as the corporate debtor, who is the corporate guarantor, demanding repayment of the outstanding amount. So in such a case scenario, I just ask a question, just throwing it to the audience, anyone can answer. Proprietorship commits a default, corporate guarantee is given by a corporate debtor, by a company, whether a section 7 can lie against a corporate guarantor when the principal borrower is a proprietorship. That is the question to be answered here. Any suggestions or any output we can receive here?
Yes,
Probably the default should be made by the corporate entity.
And not a proprietor.
Yes. So
right.
The answer, my answer may be, if the default is made by the corporate entity, then it is okay.
Okay, and principal borrower, we know. So in all cases where a proprietorship concern is the main borrower, the principal borrower. So
right, and the guarantee was given for the Mahavir Construction to the financial creditor. Mahavir
Yes.
Construction principal borrower defaulted, there is no cause of action. But
Right.
if financial creditor approached for the default made by the Surana Metal as a corporate guarantor, then the cause of action should arise. This is my view.
So if you say, which means if Surana Metals was the principal borrower, only then the Section 7 petition should be admitted. Is that what you're trying to say?
I'm not categorizing principal borrower or corporate debtor, because if the principal borrower, be it is a proprietorship firm, and if the corporate guarantor, after making default by the Mahavir Construction, corporate guarantor has defaulted, then the action lies against the corporate guarantor.
Yeah, so that means there has to be, at what we can say from the discussion is, the creditor should also give a notice of demand to the guarantor, and the guarantor should also commit a default.
Right.
Right.
Yes.
Which means guarantees need to be invoked.
Yes.
Guarantee needed to be invoked.
Yes.
Right. So that's correct. That's correct. You're absolutely right. I mean, without invocation of guarantee, of course, guarantor is not liable. Especially until unless guarantor has given up that right, which usually it doesn't. So respond number 1 here. So okay, next slide. We already seen the facts. Next. For FC, now FC files an application, an OA of an original application, which is the suit for recovery under the DRT Act, against the principal borrower before the DRT Kolkata. Now, during the pendency of the action, the principal borrower failed to pay the outstanding amount. Financial creditor sent a notice of demand under Section 4 of IBC to the corporate debtor on 3rd December 2018. The CD replied to the said notice of demand, clarifying that it was not the principal borrower nor owed any financial debt to the financial creditor. So corporate debtor stand, which is the corporate guarantor, is that I am not the principal borrower, neither I owe any financial debt to the financial creditor, and had not committed any default in repayment of stated outstanding amount. Next. Then the financial creditor filed an application under Section 7 of the IBC for initiating CIRP against the corporate debtor before NCLT Kolkata. Preliminary contention against this application was that Section 7 petition was not maintainable because the principal borrower was not a corporate person, and that it was barred by limitation. So there were 2 issues raised. First, the principal borrower is not a corporate debtor, and since insolvency IBC proceedings qua the individuals had not begun at that time. So therefore, Section 7 itself was not maintainable against the corporate guarantor. It was held that, and then second issue was regarding the limitation aspect. So after 3 years of commission of default, the financial creditor could not have approached the NCLT, and the principles for acknowledgement of debt, part payment, could not be made applicable to NCLT proceedings. Now, it was held that the action had been initiated against the corporate debtor, being co-extensively liable to pay the debt of the principal borrower, and having failed to do so, became corporate debtor and thus liable to be proceeded with under Section 7 of IBC. Now, regarding the second objection, it was found that the principal borrower and the corporate debtor had admitted the debt time and again. So there was admission of debt, lastly on December 2018, and thus the application filed after 3 months only on 13th February 2019 was within the limitation period. Next slide. Now the appellant, so NCLT admitted the application. Based on this ground, the appellant approached the NCLAT, New Delhi, by way of company appeal. NCLAT dismissed the appeal, affirmed the decision of NCLT. Appellant finally approached the Supreme Court by way of appeal, reiterating the two preliminary objections. Issues for determination. First, we've already seen whether an action under Section 7 of IBC can be initiated by a financial creditor against a corporate person concerning guarantee offered by it in respect of loan account of principal borrower who had committed default and is not a corporate person. So because the principal borrower is not a corporate person. So second, whether an application under Section 7 IBC filed after 3 years from the date of declaration of loan account as NPA, being the date of default, is not barred by limitation. At that time, that was the practice. NPA date used to be treated as the date of default. So that is why the question of NPA also coming here. Next. Issue 1, first issue, section what the Supreme Court observed, found. Section 7 permits the financial creditor to initiate CIRP against the corporate debtor. Second, CD can be the principal borrower. It can also be a corporate person assuming the status of corporate debtor, having offered guarantee upon default in payment by the principal borrower. The obligation of guarantor is, as Contract Act says, coextensive, coterminous with that of the principal borrower to defray the debt as predicated in Section 128 of the Contract Act. In the context of provisions of IBC, if the guarantor is a corporate person, as defined in Section 3, subsection 7 of Code, it would come within the purview of expression corporate debtor within the meaning of Section 3, Clause 8 of IBC. So here it clarifies corporate debtor includes a corporate guarantor also. Next. Now, then it also drew support from Section 3, subsection 37, which says that the definitions contained in other acts will also be read, and the lender would be a FC within the meaning of the code. The principal borrower may or may not be a corporate person. But if a corporate person extends loan guarantee for loan transaction concerning a principal borrower, it would still be covered within the meaning of expression corporate debtor under Section 3, subsection 8 of IBC. There is no reason to limit the width of Section 7 IBC, despite law permitting initiation of CIRP against the corporate debtor, if and when the default is committed by the principal borrower, as the liability of guarantor to pay the outstanding dues would get triggered co-extensively. The Supreme Court also relied on Section 5, Clause 5A, as it defines the expression corporate guarantor to mean a corporate person who is the surety in the contract of guarantee to a corporate debtor. The expression corporate debtor is defined in Section 3, Clause 8, which applies to the code as a whole. Whereas Section 3 is applicable to the code as a whole. Section 5 is applicable only to the part of CIRP. Whereas the expression corporate guarantor in Section 5(5)A applies only to Part 2 of IBC. Upon harmonious and purposive construction of provisions, it is not possible to extricate the corporate person from liability arising on account of guarantee given by it in respect of a loan given to a person who is not a corporate person. So even when the principal borrower is not a corporate person, even in such cases, the corporate guarantor will be treated as a corporate debtor. On the issue number 2, which is on limitation aspect. So ordinarily, upon declaration of loan account as NPA, that date can be reckoned as date of default. This is in those times when this was done 2-3 years back. Now we all know that date of default, we have to take the IU's report into consideration. Also, when default is committed, it is only after 3 months of commission of default that the NPA is usually declared by the financial creditors. So given that background, this debate of the date of default being the date of NPA is now over. But at that time, because the applications were already filed in 2018, 2017. So in such cases, the NPA usually was taken by banks as the date of NPA as the date of default. However, Section 7 comes into play when the CD commits default. Section 7 consciously uses the expression default, not the date of notifying the loan account of CD, corporate person as NPA. So here also the Supreme Court clarifies that default is different from NPA. Default is when you owe a debt and you don't pay it. NPA is a particular classification of an account by a creditor in terms of the RBI guidelines. Now, the right of the FC to initiate action against the CD would get triggered the moment the principal borrower commits default due to non-payment of debt. Thus, when the principal borrower or the guarantor admits and acknowledges the liability after declaration of NPA, but before the expiration of 3 years, including the fresh period of limitation due to acknowledgements, it is not possible to extricate them from the renewed limitation accruing due to the effect of Section 18 of the Limitation Act. So this is all settled now. At that time, it wasn't. That Section 81 of Limitation Act is now applicable to IBC proceedings. The benefit of acknowledgement of debt by the corporate debtor will be given to the financial creditor. Section 18 would come into play every time when the principal borrower or the CD acknowledges the liability to pay the debt. NCLT as well as NCLAT have adverted to the acknowledgements by the principal borrower as well as the CD after declaration of NPA. So here, not just the CD, but the principal, not just the principal borrower, but even the corporate guarantor had acknowledged the liabilities. The fact that acknowledgement within the limitation period was only by the principal borrower and not the guarantor would not absolve the guarantor of its liability. So here also the Supreme Court takes a stand. Here in such cases also limitation, because the principal borrower has acknowledged, so the liability of the guarantor also, it is not as if it is time barred for the guarantors. Next. Now, after this judgment of Lakshmipat Surana, there are some more judgments of Vishal Jaiswal is there. This is the landmark. All this, I hope everyone is aware about the background. Initially, limitation aspect, considering that when the IBC was enacted in 2016, there was no provision that the Limitation Act is applicable to IBC proceedings. Then a judgment of NCLAT came, Justice Mukhopadhyay, especially holding that Limitation Act is not applicable to IBC proceedings. And to overcome that judgment, statutory amendment was made and Section 238A of IBC was enacted, which states that Limitation Act is applicable to Section 7, 9, and 10 proceedings. And then there was a debate about whether the principles under Section 18 and Section 19 of Limitation Act, which give benefit of part payment and acknowledgement to the plaintiff in a civil suit, whether they are applicable to IBC proceedings also. And then there was a judgment of B. Padma Kumar, 5-judge NCLAT bench, which held that the principles of Section 18 and 19 will not be applicable to IBC proceedings. But then later, Supreme Court overturned that judgment in Vishal Jaiswal, which is in bold, Asset Reconstruction Company versus Vishal Jaiswal. So after this Vishal Jaiswal judgment, we have subsequently got many other judgments reiterating the stand of the Supreme Court that principles of acknowledgement of liability under Section 18 of Limitation Act are applicable to IBC proceedings. So this is the end of the second case also. I think within 45 minutes, we've covered everything. So any questions, any doubts in relation to, or any comments, any observations in relation to this judgment or the previous one? regarding Limitation Act. So two issues were there. First was the Supreme Court here actually clarified principal borrower being the proprietor, even in such cases, the corporate guarantor, even if it's a principal borrower is an individual, the section 7 IBC will be triggered. And second stand was about acknowledgement. There have been many observations, judgments. Now, usually adjudicating authorities, NCLT and FLAT, all are applying Limitation Act principles to IBC proceeding. At times, as insolvency professionals, a question also arises whether IRP can reject the time-barred claims. Any take on that? Whether IRP should reject time-barred claims or not?
In accordance to IBC, the IRP has no power of adjudication of.
Yes, that is true. But then, if you which means there is no need for verification. You just take.
Verification and verification is possible, but adjudication is not possible.
Yes. So, which means
claim cannot be rejected. That means a rejection is a you will be an adjudication. That's why it is not possible.
Right.
Apoorv, I have a little different this thing. Since the position of law have really settled as far as limitation, you have already given a number of judgments which really brings a lot of clarity on the subject. Definitely the landmark one is ARCL and Vishal Jaiswal. I think as an IRP, we should, it is not adjudication, I would say. We can keep the claim by the side. I mean, we need not admit the claim. You know, that much of jurisdiction we have.
Right.
And then there is always an option, someone can question it later on. But what I know as per my not a judgment, but as per the settled law and whatever other considerations I have to take, because some of the, even if it is not a limitation, some of the claims I have to reject because there will not be, I mean, they will be short of basic tenets of a valid claim.
See, actually, this is debatable till now because there are two things. 238A makes limitation applicable only to section 7, 9 and 10 proceedings. This is one very hyper-technical view that we can take. Section 7, 9, 10 proceedings, Limitation Act is applicable. For others, there is no, the code is still silent. Second is that as rightly pointed out by Mr. Tapan, that IRP has no power of adjudication. Liquidator has, IRP doesn't. Swiss Ribbons is very clear on it. But having said that, I also feel, at least the lawyer in me feels, not the IP in me, but the lawyer in me feels that if a person cannot trigger insolvency proceedings because his claims were time barred, how can he exercise his voting rights as a COC member? How can he join a COC if his claims were time barred? He could not have triggered section 7. How can he be a COC member then? Especially for FCs, I'm saying. So this is a question that I'm throwing upon the audience. This is quite debatable. I think till now it is not settled. Many IRPs do reject claims, they being time barred. Many don't, say that I will not touch upon it. It is not my duty. It is not my power. But so that is why. And we also have two different views just right now in our conference itself. So very two different views. And one is supported by Swiss Ribbons. Having said that, there was an insolvency law committee report also, which says that, which moots and supports this view that claims which are time barred should not be admissible. Though they don't specifically say that IRP should reject them, But at least they say that the claims which are not time barred, which are time barred, they should not be made admissible. So 238A, if you really read, it is only applicable for section 7, 9, 10. It is not saying that it will apply to the stage where the verification of claims is being done by the IRP under regulation 13. So, again, I won't say it's a gray area, but it's an area where there are two definite stands taken by two different sets of professionals.
Apoorv, just to understand clearly on this matter, suppose some operational creditors have filed a case and case is admitted under section 9.
Right.
Now the case NPA in the books of FC is made in 2014 or 15 like this way, and they were just sleeping on that. They were not filed any case in under section 7 or something. No action has been taken. Now, once the CRP started, they filed a claim. Okay.
Right.
So you can't say at that time that it's a time barred and you have no not to say anything, and I will reject your claim.
No, but if the creditor had declared the account as NPA, it must have initiated SARFAESI measures.
No, nothing they have done.
Even not even an OA was filed.
Nothing.
So because I am saying
now which you told that now the default means anything which has been filed with the IU. Okay. Now IU records are also not there. So no action is taken by the bank for last 7 years or 6 years like this way. So
yes.
Whether the IRP can reject the claim? No, because they are the only one FC in the organization. So what to do?
See, actually, this is again, it's a situation tricky. Two stands taken by different IRPs. I am saying here only itself. So that's why, depending on who is the IRP, you will take it.
But the law is not clear right now.
Law is not clear. Law is not actually, this kind of question has not arose before higher courts. And to be frank, I have also some doubt in my mind regarding section 65B, not 65C, but 65B. So when you see section 60 is applicable and 65B says that regarding the adjudication of claims, the NCLT has power during CR. If you have ever seen 65B. So NCLT, adjudicating authority, has powers to adjudicate on the claims, which means just in case such kind of situation happens, as what you have pointed out, should the IRP approach the NCLT and say, please adjudicate this? Or should the IRP take a stand and then the claimant should go and approach NCLT?
See, generally, I will just explain you that in the case of any claim which is barred 90 days, we are not accepting the claim and saying them that you approach the NCLT to take a guidance on that. And if the NCLT will order under section 65B, then we will take your claim. This is the situation which some of the IRP take.
No, this is very different what I'm saying. See, you are saying that the claimant did not follow the timelines and filed claim belatedly.
Okay, you are talking about the
limitation aspect.
Yes.
That's what you have said. So why is 65B, when NCLT, adjudicating authority, has been conferred a power that any claim made by or against the CD can be decided by the NCLT under 65B? So these questions really have not been raised before the higher courts. And perhaps why the Supreme Court in Swiss ribbons, especially pointing out that IRP has no adjudicating power, but liquidator has, is precisely perhaps because of these provisions. Now, point is also, what are the consequences if NCLT keeps exercising its power? We know how much delay is there in NCLT. The CRP will go for a toss.
Apoorv ji, the case which Rakesh ji just bataye, kya, this one financial creditor and he has not initiated anything in 7 years. Yeah.
Yes.
And now when an operational creditor section 9 application gets triggered and admitted and CRP starts,
Right.
yeah, then you have only one financial creditors and then he files his claim. So in that case, with a limitation, this thing, he cannot come in the COC first of all. And when there is no financial creditor, then the COC will be constituted by the operational creditors.
Kabir ji,
Whatever guidelines is given.
When you are the IRP, you will take the stand.
No,
But what if Mr. Tapan is there? I think he took a different stand. So that's why there is a conflict.
Very interesting case, Rakesh ji, aapne bataya. So I thought that
Let me also discuss one more.
I have a view in.
Sir, I think.
You see, people cannot be a fly-by-night operator. In this is a serious case, a CIRP. The intent is a resolution.
It's a very serious case.
Yeah, fly-by-night operators coming and putting their claims and want to be in the COC. I think this is also, it is our duty to protect the organization.
Must have written off its debts. That bank must have written off its debts.
Yes.
Provisioning bhi kar rakhi hogi. But then second, there is another aspect.
Actually, sir,
right. Sir,
what approach we take in these cases, we ask the financial creditor to prove that this is not time barred, his claim is not time barred. It may be in a way which is acceptable otherwise, as per Companies Act or as per the Banking Act also and other acts also. If there is the reflection of this particular in the balance sheet of the CD, also we accept it. If these certain things arises like that, there is no way, there is no SARFAESI action or SARFAESI case lying, and that there is a possibility that particular account has become time barred. In those cases, we tell them for alternative evidences to place before us, as that you can accept it. If it is not accepted, what we advise the financial creditor that your claim is not admitted. We never tell your claim is rejected. We tell it is not admitted. You approach the court. For adjudication. And as per the direction, we shall be accepting or rejecting. As per the direction of the court, we shall take it or not take it, your claim.
So which means of 65B only, right?
Yeah.
Right. So, but there is another thing, sir. Now, here is a case when he's talking about, when the case was taken out, some operational creditors filing Section 9 and there being only one FC. Now, what about a case where there is a consortium of agreement? Okay, I've seen such cases also. Let's say there are 10 lenders in that, a big account. Okay, a Section 7 petition filed by only one FC. Other 9 FCs stay silent. One FC being the lead bank has filed only Section 7. No other recovery proceedings. Okay. Now, for some reasons, that Section 7 petition is pending for more than 3 years. And then after 3.5 or 4 years, that Section 7 IBC petition is admitted. Now, from the date of insolvency commencement date, you will evaluate the claims. Right?
Yeah.
And especially when the Section 7 IBC petition filed by only one FC, other FCs having not taken any steps, but the liability arising from a common loan agreement. What will be your stand?
See, there is an intercreditor agreement also there. No?
Intercreditor agreement. Sir, intercreditor agreement will not be for Section 7.
No, but that actually puts on the responsibility of on the other banks also to act on behalf of the other lenders in the consortium.
The lead bank can act and file a common OA, but let's say no OA has been filed. And these are actual cases.
I've got a different view here.
Right.
See, what I feel this Limitation Act, the period of 3 years under Limitation Act has been provided to initiate any legal proceedings. If it is barred by the Limitation Act, you cannot initiate any legal proceedings in that case. But that does not state that you don't have a liability or you don't have a claim on the client. So even if it is barred by limitation, but you can substantiate that there was a liability or there was a claim pending on the CD, then the IRP or the RP has to admit the claim.
Right.
In nowhere in the section, nowhere in the act, it is mentioned that it is barred by limitation, then the RP will not admit.
No, but Sandeep sir, one more thing. During CIRP, IRP will take a stand. Yes, please let us admit his claim. But in the event the company goes into liquidation, the same IRP will say as liquidator, these claims are time barred. If I sell off these assets, I will not give you any money.
Sir, limitation
Now, here is a catch,
bar
sir.
the remedy.
Sir, now here is a
Basically,
catch.
limitation.
So now, if like what you stated just a few minutes back, that many banks have already provided a return of the loans, that does not mean that they have foregone their action or foregone their liability. They have written off or they have provided in the books, but the liability continues. And the corporate debtor is still liable to the banks and the financial institutions.
That is what I'm saying. So, but you cannot yourself file a Section 7 because your claims are time barred. Because we all know Limitation Act is applicable on Section 7, 9, 10, whatever.
That is only for the initiation of Section 7.
That's correct. So once claims are filed, claims are collated for two purposes. For filing, mainly for purpose. One major reason is for collating claim is to form a committee of creditors. Now, while the person who could not have triggered Section 7, but being a financial creditor, can sit and have voting rights as a member of COC, is it acceptable or not?
Yeah, if the claim is genuine, then it is acceptable.
Right. No,
So in that case, one example for statutory dues like income tax dues or any sales tax dues, if it is pending for 10 years and the income tax department has not initiated any legal proceeding, whether it is barred by limitation.
There are different regulation 36. This section 36 comes into picture, and these are also EPFO and all are also hot topics these days. After Jet Airways judgment also. That,
and after this Rainbow paper case by the Gujarat
the Rainbow of Supreme Court and then Jet Airways of NCLAT, just in November, a judgment came.
Correct.
That the resolution plan has to provide for full payment of EPFO dues.
Because they are standing at par with the secured creditors.
In fact, we are also facing a problem as advocates for COC in a matter. And there also the liquidation value of the corporate debtor was 36 crores and the EPFO dues were 162 crores. And the resolution, now here is a catch, EPFO filed claim before the IRP and the resolution plan was approved by COC. But because of the Jet Airways judgment, very recently, that resolution plan was held to be against 32E. So against the provisions of law, because of the Rainbow Jet Airways judgment, that the EPFO dues were not provided in full by the resolution applicant. Now this is an anomaly. When the liquidation value is 36 crores, EPFO dues are 160 crores. Who will be a resolution applicant? कौन देवता आएगा जो इतने ज़्यादा dues देगा 36 crore की limitation value? And then what will happen to COC? COC will not get any money at all.
So the thing is, this judgment, after this judgment,
right.
They don't know what liability they have to pay for the government and how they will pay.
That's correct. So no, there are situations, and actually these are EPFO dues. Now these are all special acts, Employee Provident Fund Act.
That's okay, but the company, we have to understand one thing. The company is in problem. Company is insolvent. They don't have money to pay to the creditors. If they have money to pay to the creditors, there was no reason to go in insolvency.
That's correct.
And when someone is giving their helping hand to run the company, to run the show going forward, and with some amount paying to the financial creditors, which was the objective of the IBC, and even in the first IBC report also, it was told the basic thing that why financial creditors is getting COC seats, why they are going to be paid in first, and all those things they have discussed in detail. And again, if the government is not laying off all the dues, then there is no need of this IBC going forward. Timelines and everything is keeping it separate, and timelines is only for the IRP, RPs, and for the other actions. For the court, it was also, again, it is not mandatory. It's a what we say. It is not a mandatory. It's a recommendatory. Now IBBI is not asking for that. IBBI is looking at that everything should be time bound, and you should be rewarded, and you should be punished if you are not adhering the timelines. But if you ask me as a RP, RP have to not only to do the compliance work, but they have to run the troublesome company in a manner that it should be going concern. It should be given to the resolution applicant as a going concern, and looking for the resolving the issues at the city. Whereas it is missing in some of the recent judgment, where they are looking at, everyone is looking at recovery. We are already facing the problem of financial creditors looking for the recovery rather than a resolution. And again, this will last nail into the this law.
That's correct. This is the last what do you say? The last
nail of the
corporate.
Okay, yeah.
Is the only the last chance before it dies as a in the liquidation process.
Because there is no other way. The company can be dissolved or the squared off from the books if they have any liability. People are using this NCLT route to close down the company wherever they don't have any business or not having future looking at, and where they are unable to pay it debts. Okay, I understand there may be 5 to 10% cases where there are fraud or there are mishappening happen, because after the limit has been increased to 1 crore, the problem is still there. We are still lagging behind on the judgments.
That's correct. You're right. No, but the main issue in these days is about the APFO. That's correct.
Yes.
But yes, the food for thought that I wanted to present because of the applicability of Limitation Act in Lakshmi Surana,
Correct.
That this anomaly, whether IRP should accept claims which are time barred or not, is really not clear even after Swiss Ribbon's judgment.
Yes.
As we see, some of our participants only saying that, yes, we will reject those claims. We will not admit those claims. I won't use the word rejection, but they will not admit those claims which are time barred. But then some will do. So, to be frank, either IBBI should come up with a regulation, should make some amendment in the CRP regulations specifying specifically, or the code or the parliament should come up with an amendment specifying whether IRP should be allowed to admit or not admit, because there are pros and cons of while adopting both the approaches. That's what I've seen.
Correct.
There are pros while admitting claims which are time bound, and cons also.
Yes.
So, because I also can't see that a person who could not have filed a time barred claim and triggered insolvency process gets to sit as a COC member, exercising voting rights, taking control of the corporate debtor, administering through RP itself, but on the direction of COC. And then if you go into liquidation, if the same RP becomes the liquidator, he will reject those claims being time barred and say, I will sell off these assets of the corporate debtor, but you will not get anything, even though you are a member of COC.
Now the situation has changed. The new rules have came. IBBI has given the circular where you have to admit all the claims which has been given in the CRP period. Now, after 2 years or after 1 year, when the liquidation order is there, how you will, even if they are not filing a claim, you have to accept. It means there is no need of educating the point which you are taking right now.
So these are anomalies. These are anomalies being introduced by the amendments or regulations. But even otherwise, see, I don't see a same professional taking 2 different stands at different stages. It's something that I can't digest. So NCLT says you can't file section 7. IRP says no, but you can sit in the COC. But liquidator says no, sorry, rejected. I will not distribute any proceeds to you. Your claims were time barred. So this is an anomaly to me. Any other topic of discussion anyone wants to? I hope I know I'm able to engage the audience to some extent.
Benefited with your views.
Thanks. But see, these are questions that have come into mind. I don't have definite answers to certain questions.
Sir, shall I make ask one clarification, sir?
Sir.
Regarding section 10 application,
Section
where
10.
comes the limitation, sir? Because the corporate debtor himself filing the application.
Yeah, so
Against
limitation.
whom?
Yes, no, so section 10 limitation will come when he says, I committed default of a time barred claim. Then NCLT will say, sorry, you cannot go into section 10.
No CD will sell. Because acknowledgement has to give by the CD only.
On paper, we have it applicable that, but then if the CD itself is acknowledging it within 3 years and filing a section 10, that itself
CD will give, sir, because it is a escape route. Of course, if he is not able to pay the debt, then where comes the question of section 10 application?
No, that's correct. You are absolutely right.
Thank you, sir.
Any other questions, comments?
Are there any other questions, or we may end the session? Okay, so on behalf of everybody, I thank you, Mr. Apoorv, for taking up the session. You made it very informative as well as interactive. Thank you for the session. And I think one of the key takeaways from your session was that CIP proceedings can be initiated against the guarantor being a corporate person upon default made by a principal borrower who is not a corporate person. So thank you. Thank you so much for taking up the session. And thank you to all the participants also for taking the session. Thank you.
Thanks a lot. Thanks a lot. Thank you very much.